You know how sometimes a tiny little problem in a neighborhood can just blow up? Well, that's exactly what we're looking at today. We're going to open up the case file on a dispute that started with something as simple as a damp wall and turned into this whole multi-year legal showdown between a homeowner and his HOA.
Yeah, it all started with a wet wall. Sounds pretty straightforward, right? A little moisture, no big deal. But this wasn't just any wet wall. This thing became ground zero for a massive dispute that really put everyone to the test: the homeowner, his neighbor, and their entire homeowners association.
And just look at this timeline. This thing dragged on forever. Mr. Martin starts complaining way back in 2005. But get this, it takes over a year just for the HOA to send a formal violation notice. And then another whole year before it gets to a hearing. So this wasn't some quick argument that got out of hand. Oh no, this was a slow, agonizing, frustrating burn for everyone involved.
All right, so here's how we're going to break down this case file. We'll start with the problem on Beechnut Drive, check out how the HOA handled it, figure out why it got stuck as a neighbor-to-neighbor thing, and then get to the good stuff, the judge's final call and the order that wrapped it all up.
Okay, first up, what was the actual problem on Beechnut Drive? To get to the bottom of this, we first need to meet the folks involved and understand what the complaint was really about. All right, so here are the key players. You've got the homeowner, a Mr. John C. Martin. Then you've got his neighbors, the Downings. Now, the problem was that the Downings were running a plant servicing business right in their backyard. And Mr. Martin's complaint was pretty specific. He said their overwatering was constantly soaking the wall they shared, and it was seeping through and causing damage on his side. Now, here's a little twist. You might be thinking, oh, they were running some illegal business, right? Nope. The Downings actually had a permit from the City of Chandler. That's a super important detail, so tuck that away, because it's going to come back in a big way when we talk about what the HOA was supposed to do. Okay, so Mr. Martin does what you're supposed to do. He complains to the HOA. So how did they respond? Let's walk through what they did do, and more importantly, the one crucial thing they didn't. So on the surface, it looks like the HOA is following the process, right? They send out a couple of courtesy letters. Then after Mr. Martin sends them some photos, they escalate it to a formal violation notice. They even send a property manager out to inspect both properties. Everything seems by the book. Until step 4. The board just assumed the problem was fixed after that visit. And that one little assumption, that's where everything started to fall apart. And when you dig into that site visit, you see the massive oversight. The manager, he saw it all. He saw the misting system right by the wall. He saw that both sides of the wall were wet. He told the Downings, hey, you gotta move the plants, turn off the system. But, and this is the whole case right here, he never went back. Not once. No follow-up visit to see if they actually did what he asked. The entire fix was just based on a promise, with zero verification. So because there was no follow-up, you end up with this total standoff. From Mr. Martin's perspective, nothing had changed. The wall was still wet. But from the HOA's point of view, case closed, problem solved. You've got two groups looking at the exact same situation and seeing two completely different realities. And this is the heart of the conflict right here. Mr. Martin is saying, look, the watering is still happening, the damage is still happening, and you guys, the board, are not doing your job to stop it. The HOA's response? They basically washed their hands of it. They said, we looked into it, and now it's just a neighbor-to-neighbor dispute. It's not our problem anymore. And that one question, is it the HOA's problem or not? That's what sent this whole thing to court. So, with neither side willing to budge, Mr. Martin took the next step. He filed a formal petition, which meant the whole mess landed on the desk of an administrative law judge. Now it was up to the judge to sort through all the back and forth and figure out who was legally right. But before we can get to the judge's conclusions, we have to quickly talk about the rule book they were using. It's all about the CC&Rs, the covenants, conditions, and restrictions. You can think of this as like the official rule book for the whole community. They were legally binding, and every single homeowner agrees to follow them when they move in. So that leads to the first big question the judge had to answer. Remember how the Downings had that permit from the city? The real question was, even with that permit, was their business still a violation of the HOA's own rules, the CC&Rs? And the answer from the judge was a big, clear yes. The business was a violation. And this is a super important takeaway for anyone who lives in an HOA. Your community's rules can actually be stricter than the city's rules.
In this case, the CC&Rs flat out said no to this kind of business, which basically made that city permit worthless inside the boundaries of their neighborhood.
Okay, so check. The judge confirms the Downings are breaking the rules. That naturally leads to the next question, which is maybe even more important. Did the HOA drop the ball? Did they actually do their job and enforce their own rules?
And once again, the answer from the judge was a resounding yes. The HOA did fail in its duties, and it all came back to that one missing piece. They never did a follow-up visit to confirm the problem was fixed. The judge made it clear the board can't just cross its fingers and hope for the best. They have a legal duty to make sure the rules are actually being followed.
All right, so with all that decided, it was time for the judge to issue the final order. Let's take a look at what the verdict was. First things first, let's talk money. The judge ordered the HOA to pay Mr. Martin back his entire filing fee, $550. That pretty much made it official. Mr. Martin had won. But this was never really about the $550. The real bombshell in the ruling was this direct order from the judge. He basically told the association, you have to comply with and enforce your own rules. It was a total smackdown of their whole argument that this was just some neighbor-to-neighbor issue they could ignore.
So, in the end, what started with a damp spot on a wall, well, it ended up setting a major legal precedent for that entire community. It really gets you thinking, doesn't it? Rules on paper don't mean much if no one enforces them. And this whole case proves that sometimes the answer to that big question, who holds your community leaders accountable, is just one determined homeowner who isn't willing to back down.